Jeffrey Deskovic, then 18 years old, was wrongfully convicted for the 1989 rape and murder of a classmate. In January 2006, the Innocence Project took on Deskovic's case and established by DNA evidence that he was in fact innocent and that another person had not only committed that murder, but had gone on to commit another murder. Jeffrey, go ahead. The stage is yours. Thank you, and thank you for coming.
Thanks for having me. Happy Mother's Day to everybody, by the way. Can everyone hear me?
Yes.
Okay. In 1989, a classmate of mine was found murdered and raped. Peekskill was a small city in Westchester County, New York, the suburbs. Murders were pretty rare. So when this murder happened, it understandably created an atmosphere of fear, rumor, paranoia. Parents were concerned with their own safety as well as the safety of their children. In high school, I was quiet. I was to myself. I didn't participate in a lot of organized sports. This made me seem strange to the kids in the high school. In the course of the police investigation, the police spoke with many students from the school, and some of them told the police they might want to talk to me because I didn't quite fit in. This is what the police said initially attracted them to me. The other factor which they said attracted them to me is they said that I was overly upset at the victim having been murdered. They interpreted my being sensitive and sentimental as being an outward sign that I was sorry for what I had done. Okay, give me 1 second here. Just this issue with the volume.
Jeff, I think they'll have to turn their volume up. I'm not sure you can really control it.
Okay. All right. All right. So I'll repeat the last part. So the police interpreted my being emotional and sentimental as an outward sign that I was sorry for what I had done. In addition, the Peekskill Police Department, they got a psychological profile from the NYPD, which purported to have the psychological characteristics of what the actual perpetrator would be like. So that was a type of reinforcing factor. For about 6 weeks, the police played this cat and mouse game with me, in which half the time they would talk to me as if I was a suspect, and the other half the time they would pretend like they needed my help to solve the crime. They would say things like, "The kids won't talk freely around us, but they will around you. Let us know if you hear anything. Stop in from time to time." They made me feel important. They made me the center of attention. They would ask me opinion questions and congratulate me that my opinion was correct. Before I was a teenager, the fantasy career that I wanted to have when I grew up was actually to be a cop. So that, along with my age, 16, was how the police were able to pull the wool over my eyes as to the absurdity that a 16-year-old would be able to assist them in an active homicide investigation. I came from a single-parent household. My father was never involved in my life in any capacity, and that directly intersected with the police technique of good cop, bad cop, otherwise known as Mutt and Jeff, in which one officer takes on a more aggressive role, whereas his partner pretends to be opposed to what's going on, yet somehow powerless to intervene. The purpose, of course, of this tactic is that when a person being questioned, the suspect becomes frightened, it's only natural that you would look to a friendly face for assistance. Eventually, they got me to agree to take a polygraph test by telling me that some new information had come into the police file and they wanted to share that with me, and that would put me in a better position to help them. First, though, I would have to take and pass a polygraph. So the next day, rather than report to school, I instead went to the police station for this test. Because it was a school day, that meant neither my mother or grandmother with whom I lived, they had no idea that anything was wrong. As far as they were concerned, I was in school, and therefore they did not call around looking for me. They drove me to the town of Brewster, which was in Putnam County, whereas I was a native of Peekskill in Westchester County. So it was about 40 minutes away by car. And the reason why that's important is that that meant that I was no longer able to leave on my own. I was instead dependent upon the police. There were 3 officers who came with me from Peekskill to Brewster, but then there was also the Putnam County Sheriff's investigator, the polygraphist, who was dressed as a civilian and he was pretending not to be a police officer. He never read me my rights. I did not have an attorney present. I wasn't given anything to eat the entire time that I was there. He gave me a 4-page brochure which explained how the polygraph worked, but it had a lot of big words in it which I didn't understand. But then I pushed past my own concern by thinking, well, I'm there to help the police. What does it matter? Let's just get on with it. So from there, I was put into a small room and I was given countless cups of coffee. Seems fairly clear in hindsight that the purpose of the coffee was to make me nervous. From there, I was attached to the polygraph machine, and so now I was fairly immobile. And from there, he then launched into his 3rd-degree tactics. So he raised his voice at me. He invaded my personal space. He kept asking me the same questions over and over again. He seemed to be getting more and more ferocious as each hour passed. As each hour passed, my fear increased in proportion to the time. He kept that routine up for 6.5 to 7 hours. Towards the end of the interrogation, he made a statement to me. He said, "What do you mean you didn't do it? You just told me through the test result that you did. We just want you to verbally confirm it." When he said that to me, that really shot my fear through the roof. At that point, the officer who had been pretending to be my friend, he came in the room and told me that the other officers were going to harm me, but that he had been holding them off but could not do so any longer. "You have to help yourself here, you understand." Well, considering that I had maintained my innocence for the previous 6.5 to 7 hours, it was clear what he meant by that. They wanted me to confess. When it was added that if I did as they wanted, that they would stop what they were doing, that I could go home afterwards, being young, naive, frightened, 16 years old, not thinking about the long term, instead only being concerned with my safety in the moment. I was in fear of my life. The fact that I didn't know where I was and that nobody else knew where I was loomed very large in my mind. I had not been used to talking with adult males, let alone the way that that officer was conducting himself. And so being overwhelmed emotionally and psychologically, plus the push-pull dynamic. On one hand, the possibility of harm had been introduced, and on the other hand, he had thrown me this false life preserver. I decided to make up a story based upon the information which they had given me in the course of the interrogation that day and in the 6 weeks run up to it, as well as some items from the newspaper. By the time the interrogation was finished, I was curled up into a fetal position, crying uncontrollably. Needless to say, I was arrested. I was charged with a murder and rape. Now, before I went to trial, the results of a DNA test came in from the FBI lab, showing that semen found in the victim did not match. But rather than acknowledge they made a mistake, they instead continued to prosecute full speed ahead. In order to explain away the DNA evidence, the prosecutor got the medical examiner to commit fraud. When there's an autopsy done, there's written and audio notes which are taken as findings are made. It was only 6 months after doing that autopsy, and only in response to the DNA not matching me, that suddenly this medical examiner claimed that he remembered that he forgot to document medical evidence showing that the victim, a 15-year-old immigrant from Colombia who had been in the country for about 1.5 years, leading a pretty sheltered life. She never went anywhere unless she was accompanied by her older sister or her parents, that she had been sexually active, which is what opened the door for the prosecutor to argue that it didn't matter that the DNA didn't match me. That didn't mean I was innocent. It was just yet another person who she had supposedly slept with prior to my murdering and raping her. Taking it a step further, he actually named another youth by name that he claimed he had had this encounter with the victim. Yet he never set the proper evidentiary foundation for that. He never had a DNA test performed on this other youth. He never even called him as a witness to give verbal testimony to that effect. He simply made the unsupported argument to the jury. At the same time, the public defender that I had essentially didn't defend me. He never interviewed or called as a witness my alibi. I was actually playing wiffle ball when the crime happened. He rarely met with me. Whenever he would meet with me and I tried to explain to him that I was innocent and what had happened in the interrogation room, he was always shutting me up. One time he told me he didn't care if I was guilty or innocent. My lawyer should have never represented me in the first place because of a conflict of interest. This other youth that the prosecutor was falsely claiming had slept with the victim was represented not only by another member of Westchester County Legal Aid, but also specifically by the lawyer who was supposed to be supervising him in my case. And so that conflict prevented the defense from calling him asking him for a DNA sample or from calling him as a witness. When it was time to cross-examine the medical examiner, my lawyer stood up in open court and with a big smile on his face, said to the medical examiner, "You're going to be pleased to know that I don't have a single question for you." When I hadn't decided if I was going to have a bench trial, which is decided by a judge, or a jury trial, my lawyer came to me one day and told me that the trial judge came to him off the record and told him to pick a jury because he didn't want to be responsible for finding me not guilty. My lawyer was supposed to put that on the record and ask him to recuse himself because, number one, it was not proper for him to limit my decision that way. Secondly, that suggests bias, and perhaps that the judge was feeling some public pressure because, every time I made a court appearance, it was a major media moment with virtually all the coverage from a guilt presumptive oriented perspective. When I was interrogated, the interrogation was not videotaped. It was not audio taped. There was no signed confession. There was simply the officer's word for it. And as a result of that, they were able to leave out the threat and false promise out of their testimony. So I wanted to testify at the pre-trial hearing. So whenever there's statements made, the court has to hold a pre-trial hearing to determine whether or not the suspect was given their rights and whether any statements that they made were voluntary. So because the statements hadn't been videotaped or audio taped, I wanted to take the stand and testify as to those facts. But my lawyer wouldn't allow me to. He told me that he hadn't decided if I was going to testify at the trial or not, and that because nobody tells the same story in 100% the same way, if there was any kind of variation between my trial testimony and the pre-trial testimony, that the prosecutor could use that to make it appear as if I was lying, even if I was not. But that really didn't make too much sense because, first of all, if the judge had believed me, then the statements would have been ruled involuntary and therefore not have been admissible. And lacking that, there would not have been there wouldn't have been a trial because they didn't have any other evidence. Secondly, if it really went that badly, I didn't have to testify at the trial. And if I didn't, then there's no way that the prior testimony could have been used. But then when I got to the trial, he wouldn't allow me to testify there either. He told me that his personal win-loss record was significantly better when his clients didn't testify as compared to when they did. That's probably true because most of his clients probably have a criminal record, and if they took the stand, the prosecutor would be allowed to ask questions about that case. But that didn't apply to me because I had never been arrested before for anything. But then, secondly, the second reason he gave for not allowing me to testify is he told me that it wasn't his job to prove that I was innocent. It was up to the prosecutor to prove that I was guilty, and he didn't think that it happened. While that might be a legal principle, it doesn't actually work that way in real life. In reality, if your client is charged with a crime that they haven't committed, you have to try to prove that they're innocent, or else you run a risk of them possibly being wrongfully convicted. That's particularly so in a case where a confession is going to be used as evidence, where there's an 80% conviction rate in such cases. I mean, the general public don't believe that that an innocent person would confess. And so if you're defending a case like that, you have to answer that confession. You have to explain that confession. You have to disprove as many different aspects of the confession as you can in order to then tie it together in closing arguments towards your general argument that the confession is false and coerced, except that he didn't do any of that. Add it all up, I guess it's not too surprising that the jury found me guilty. I'll never forget the day I was found guilty. It felt like I was in some sort of nightmarish alternative reality. Because to my way of thinking, at least up until that point in time, only the guilty were convicted. Yet they said what they did, and I was taken into custody. On the day of the sentencing, I begged the judge to overturn the verdict because I was innocent, and I referenced the DNA to support my contention. He actually told me on the record, maybe you are innocent, conceding that there was a doubt. How could there not have been a doubt? The DNA didn't match me. That didn't lead him, though, to step up for justice and exercise his discretion by overturning the verdict, which he could have done by reversing any number of rulings that he had made against me in the course of the trial. Instead, he took the easy, politically expedient way out, which was to sentence me to a term of imprisonment of 15 to life. I would like to share with you a little bit about my prison experience. Let me say that because I was charged as an adult, that meant I was sentenced as an adult, and I was therefore sent to a men's maximum security prison. I still remember the first day. I remember having on handcuffs and a chain around my waist and my legs fastened together, as well as fastened to the legs of the prisoner on the bus next to me. I remember how large the prison wall loomed and how menacing the barbed wire appeared. I don't mind sharing with you that at 17 years of being 17 years old, I was extremely frightened. I also had the built-in handicap of knowing that if any of the prisoners there discovered what I was incarcerated for, that would rape along with that murder, that would serve as motivation on their part to assault me. Because in prison, there's a vigilante mentality towards people who have been convicted of sex offenses. The guards themselves were obstacles. To be sure, some were professional and did their job. Yet there were others who came to work and brought their personal problems into the facility, displacing their aggression onto the prisoners. Then there were other guards who just wanted to do their 8 hours and go home, and they didn't care what happened while they were there. While that might be an ideal attitude that you'd want a guard to have if you had to be incarcerated, it didn't actually work out that way in real life, because it would not be unusual for them to look the other way and walk in the opposite direction when violence was occurring, so as to be able to avoid breaking things up and filing paperwork afterwards. Then there were other guards who even their peers disliked, because the manner in which they conducted themselves on a day-to-day basis made it likely that prisoner-to-staff violence could occur or that a riot could ensue, which had the impact of sucking everybody in. Yet nobody ever bothered to reel them in, not their co-workers nor the people who supposedly were there to supervise them. There was a system of maintaining order in the prison known as keep lock, which involved a variety of sanctions being imposed on the prisoners if they were found guilty of having broken a prison rule. Those sanctions included being kept in the cell 23 hours a day out of the 24. They would send you less food. Sometimes the food would be 3 or 4 days old. You could take 2 showers one week and 3 the next, rather than being able to shower daily as the rest of the population. Their idea of complying with the court-mandated 1 hour a day recreation consisted of putting the prisoners in a small caged area with maybe a pull-up bar in it if you were lucky. You would not be able to use the phone while you were on that status. There was plenty of violence in the prison, Elmira, where I spent 13 and a half of the 16 years. There was 3 or 4 stabbings or cuttings every day, plenty of violence that did not involve weapons, and there was a lot of gang activity. Taken cumulatively, there was a general atmosphere of violence and adrenaline that permeated the air. There were several times in the course of my incarceration in which I was assaulted, one time in which I nearly lost my life. In addition to dealing with that physicality, I was also subjected to those sanctions, because in prison, if you were defending yourself, then obviously that meant that you were fighting. While I was in prison, I tried to minimize the loss that I was experiencing. I obtained a GED, I completed an associate's degree, and I completed a further year of schooling towards the bachelor's. But then even that silver lining was taken from me because in 1995, George Pataki became governor of New York, and he decided it would be a good idea to cut the funding of college education for prisoners. When that happened, I started attending the vocational trades, but although I completed many courses and I accumulated many certificates, the reality of it is that the curriculum was obsolete many years prior to my ever having set foot in the vocational shop. When I was originally incarcerated, my mother used to make the 4.5 hour trip from Peekskill to Elmira. But as the years grew long and it grew tiring making that long trip, and things tightened up a little bit financially, and she began to have some problems in her feet and her back, I began to see her less and less until eventually I was lucky if I saw her once every 6 months. My brother is 3.5 years younger than I am, and he also was impacted by my wrongful conviction. The kids in the school bus and in the school would tell him that his brother was a rapist, and they would try to stab him and hit him they would try to hit him. I guess being unable to get to me, he was the next best thing. In 1996, the prison authorities informed me that they had received information from the outside hospital saying that my grandmother was extremely sick and was not going to make it. And so they wanted to know whether or not I wanted to wait for her to pass away and then go to the funeral service, or did I instead want to forego the service and see her one last time while she was alive, albeit in a coma. It was a very difficult decision because by that point, I already had been incarcerated for 6 years. I had lost several appeals, and there were many members of my immediate and extended family that had never come to see me, who I knew good and well were never going to see me so long as I was in the prison. So attending this funeral service represented the last clear opportunity that I had to speak with them and encourage them to, reach out to me. In the end, I decided that I would go see my grandmother one last time while she was alive. I've always gotten motion sickness, and so one of the ways you protect yourself from getting sick is eat before you begin the journey. We left Elmira for Peekskill early in the morning prior to the rest of the population being served breakfast. The guards were given funds with which to purchase breakfast items for themselves and for me. But while they had a full complement of breakfast, I was simply provided with a cup of coffee. And as a result of that, I grew extremely sick, and they had to stop the car several times because I was on the verge of vomiting. When we got to the hospital, they parked the vehicle as far away from the hospital doors as possible so as to be able to parade me through the parking lot and the hospital corridors, again, keeping in mind that I had on handcuffs and a chain around my waist and I had my legs fastened together. I remember there was a nursing attendant on duty that did a double take at the sight of me, and there was a child running around and playing that was maybe 5 or 6 years old. And the mother got one look at me and brought the child close to her as if I was some kind of violent animal that was going to commit a spontaneous act of violence right there on the spot. Definitely a humiliating situation. When it was time to go home, the guards came go back to the prison rather. The guards came into the room and they told me that my hour was up, and that I looked up at the clock and saw that in fact it had only been 45 minutes, but they insisted it had been an hour and they forced me to leave, again parading me through the hospital corridors. This time I was given a full meal to eat, a lunch, but by this point the parking space where the car had been parked at, it had lent itself to sunlight beaming through the windshield, and so by now the vehicle had become rather hot. They turned on the air conditioning, but because there was plexiglass fully separating the back of the vehicle from the front, none of it reached me, and they were unwilling to lower the window even a fraction of an inch. All told, I suffered for between 8 and 9 hours in order to visit with my grandmother for less than one. When I reached near the end of my sentence minimum, the prison authorities told me that if I wanted to have any chance at all at making parole, which was already a slimmer than slim possibility as it was, I would have to take and complete the sex offender training program. The problem with completing that program, however, was that there was a guilt admission requirement tied to it. Everybody in the class would be expected to admit guilt to the instructor as well as the other prisoners. A verbal rendition wouldn't cut it. They wanted everything in writing. Simply saying that one was guilty wouldn't suffice. They wanted to hear all the details. Failure to complete any aspect of that would result in immediate removal from the program, with the prisoner being deemed to have refused to complete the program. So I was again in a difficult position. In the end, I decided that I was not going to take that program because I couldn't bring myself to sit there and give even more details of committing a crime which I knew that I had not committed. In the end, I went. I did not take that program, and when I went to the parole board, I knew that they were in the habit of rubber stamp denying applications of anybody who had been incarcerated for a violent crime. You know, they would simply go to parole board, be turned down, reappear in front of them 2 years later, and be turned down again, and have that cycle continuing on in this never-ending cycle of perpetuity. In reality, the parole board was supposed to be assessing whether or not the prisoner had been rehabilitated, and if they were released, you know, would they remain at liberty without being arrested again? You know, rather than just focusing in on what they had been convicted of in the first place, because you know that was never going to change, and that was why they were incarcerated to begin with, and that's in the opposite direction of rehabilitation. So I tried to protect myself from being denied parole by repeatedly raising the issue of my innocence and referencing the DNA. Uh, but they were not even willing to consider the mere possibility that I was innocent. Towards the end of the hearing, they asked me a question about an aggression replacement training program, and I was able to give him the answer, demonstrating I had learned the material in the shop. That's when a different commissioner piped up and said, "Well, that's good, Mr. Deskovic, because you're going to need those skills when you return back to society. Good luck." The procedure is that they don't inform you of the decision right there on the spot, but it's instead sent via institutional mail 3 days later. Considering how that interview ended, I actually walked around the prison for the next 3 days thinking that I had somehow defied the odds and that I would be going home. When I got the decision, it noted that I had an excellent educational record, that I had a good disciplinary record, that I had some letters of support, including from a prison employee recommending that I be paroled, but that nonetheless I had been convicted of a brutal and senseless crime, and they wrote to release me would be to somehow lessen its seriousness. They turned me down. They ordered me to appear in front of them 2 years later. And at that point, I felt like it was pretty certain I was going to die in prison as a result of being convicted of a crime which I did not commit. I would like to share with you how it was that I came to be exonerated. While all that was happening, and a lot more that I'm passing over for the sake of time, I was simultaneously appealing my conviction. I went to the appellate division, the first court one must go to. My lawyer raised the issue of my innocence based on the DNA.
Jeffrey, I don't know if you can hear me, but you seem to have frozen.
Go into. The court found that I was not in custody. I was free to come and go as I wanted. And therefore, they ruled the statements were not involuntary. They wrote that there was overwhelming evidence of guilt, which is still kind of a head scratcher because the DNA didn't match me. They got rid of all my other issues in one sentence by writing that they had looked at the remainder of my issues and found them to either be without merit or not preserved for review. They ruled against me 5-0. As terrible as that decision was, that was the most that any court ever wrote. My lawyer moved to re-argue the case in front of that court, but the re-argument motion was denied. The New York State Court of Appeals, our state's highest court, declined to give me permission to appeal to them, so I lost there. I lost in federal court because the court clerk gave my lawyer the wrong information pertaining to the filing procedure, as a result of which my petition arrived 4 days too late, which former Westchester DA Jeanine Pirro, who has the judge show and is a commentator on television, her office took the position that those 4 days were prejudicial to the people, and therefore they urged the court to simply rule that I was late without looking at my issues. And that's what the court did. Now I was time barred, so that meant I was stuck arguing that procedural ruling against me was inaccurate. So I appealed to the Federal Court of Appeals. I got permission to appeal to them on the issue of the technicality. And my lawyer argued that this was not a delay caused by me or my attorney, but by the court clerk. More sophisticated DNA testing. But the two judges on the circuit, Judge Rosemary Pooler and future U.S. Supreme Court Justice Sonia Sotomayor, they ruled with the district attorney. My lawyer moved to re-argue the case in front of them, requesting that all the judges on the circuit hear the case, but the re-argument motion was denied. And then I appealed to the U.S. Supreme Court, where it's a two-part procedure. Nationally, they only agree to hear between 2 to 5% of the total number of cases in front of them. So you knew, despite compelling reasons of justice as to why they should do so, the odds of them agreeing to hear my case were slim. Having no other court left to go to, I had no choice but to forge ahead. I was not able to overcome the odds. As expected, the U.S. Supreme Court declined to give me permission to appeal to them. That marked the end of my appeals and the end of legal representation. That was in 2001. The path, therefore, to be exonerated when the appeals are over is you have to find some previously unknown evidence of innocence, without which you're permanently locked out of the courthouse. So I wrote letters for 4 years looking for a lawyer and investigator to take my case pro bono because I didn't have any money with which to hire one, and neither did my family. I rarely got answers to any of my letters. Eventually, I wound up in touch with an investigator who, when I showed her the DNA test results, she believed in my innocence, and she suggested that I write the Innocence Project again, which is a nonprofit organization in Manhattan, New York, that frees wrongfully convicted prisoners across the country in those cases in which DNA testing can demonstrate innocence and in which no prior testing had been conducted. I wrote them before in 92, 93, but DNA was not as advanced then. And so their case selection criteria was, like I just mentioned, but the problem is I didn't meet that selection before because I had the prior testing. And so therefore, they couldn't simply test again and then use that as newly discovered evidence because it wasn't new. Fast forwarding 15 years, the investigator told me that in light of the advancement in DNA technology, that the prior denial was irrelevant and just write them again. So I wrote them again, I filled out their questionnaire, and then I forgot about it. I looked for other ways of obtaining legal representation, none of which were successful. Now, I didn't know that at the time, but I've learned since that in that 6 months time period, once again, the Innocence Project didn't want to take the case because of the pre-existing exclusion. But one of the caseworkers there, Maggie Taylor, represented my case to the lawyers. So each time they said no, she would go back to the drawing board and come up with a new theory as to how the DNA could be used, and she would come back. So on the third try, she was able to push it across the finish line, and they agreed to take my case. So obtaining their legal representation was the first of three important things. The second was that Pirro left office, and her successor was not as dug into my case, and she was willing to allow me to have the further testing that Pirro would not. And thirdly, we got lucky that the actual criminal committed a second murder. He killed a second victim 3.5 years later after killing the victim in my case, who was a school teacher and who had 2 children. So the DNA, it matched him, and he then confessed to the crime. On September 22nd, 2006, my conviction was overturned and I was released. I reported back to court November 2nd, 2006, at which point all the charges were dismissed on actual innocence grounds. I would like to share with you at this time some photographs, and while I get ready to do that, there will be some technical instruction given to you now by one of the moderators as to how you can look at the slideshow.
Yeah, thanks. Just very quickly, when Jeffrey is sharing, just as I'm sharing now, oh, no, now he's sharing. Wait, sorry. Yeah, let me bring up my picture. Wait. So if you can see the speaker and the screen. At the top, there's a little bar with view options, and if you select side by side, you'll be able to see both. That's what I wanted to show you. Go ahead, Jeffrey.
Okay. So the reason why the photos are important is because I was not the adult then that you see now. I was much younger when this happened. I was 16 when I was arrested.
I think that, excuse me, I think that, there we go.
Okay, so this is a picture of my mugshot. Wait, something is happening here. Wait, give me 1 second. Okay, and wait, I'm trying to move the I'm trying to show the other slides, but it's not working. Give me 1 second here. Okay, I got this working now, and we just okay, can you everybody see everything
Yes.
now? Okay,
Yeah.
and here and from the beginning. Okay, let's try this now. Okay, this is my mugshot. Sorry about that. Here, this is all right. So this is my mugshot. This is a picture of me in the courtroom when it was announced that the jury had reached a verdict, but prior to it having been read. With the lady with the red hair was my mother, and with the white sweatshirt, that was my aunt. This is a picture of me in the courtroom when I was given the 15 to life sentence. This is a picture of me shortly after arriving at Elmira Correctional Facility. This is another picture of me shortly after I arrived. This is a picture of me when I was released. To my left is Barry Scheck, who was a co-founder of the Innocence Project, along with Peter Neufeld. There's a picture of my mother again, and there's my attorney, Nina Morrison. I want to point out that one of the people on the presentation today attending is Matt Kelly, who used to work at the Innocence Project, doing their Innocence blog and other communication aspects of their operation. And is a picture of me giving a hug to my mother. It was very difficult to put your life back together again after being through a traumatic experience like that, particularly one that lasted 16 years. So this next photo is kind of encapsulates that difficulty. Where are we at? Give me 1 second. So let me share that the world is much different now than when it was when I was originally incarcerated. The technology was different. Cell phones, internet, GPS, those things didn't exist. These different methods of banking did not exist. The culture was different. Neighborhoods looked different. People that I knew had lived there long since moved away. Taken cumulatively, there was a general atmosphere of feeling like I was in an alternative universe, a world which I didn't belong in. It was very difficult when I would meet up with members of my extended family. It was awkward because although I knew who they were intellectually, when you spend long amounts of time away from people, they're different. The changes in them are different, and I was a different person as well. I had to deal with the stigma. Not many people questioned my innocence because the actual criminal was arrested and convicted of the crime, whereas my charges were dismissed on actual innocence grounds, and there was a report issued by the Westchester District Attorney as to what went wrong in my case. But there still nonetheless was a stigma. You were in prison wrongfully for 16 years, yes, but you were there for 16 years. How much of that rubbed off on you? Is it safe to be alone someplace with you? So that has proven to be a challenge when it comes to personal relationships. I was never able to obtain gainful employment. It seemed like every employer wanted somebody who could hit the ground running, and I would have required some on-the-job training and to get caught up on the technology. I had to deal with the psychological after effects of being wrongfully imprisoned. I used to go to mental health professionals 4 times a week for 6 years to deal with readjusting to being free and then coping with the psychological after effects. It's common when people have been wrongfully imprisoned to suffer from post-traumatic stress disorder, panic attacks, anxiety, fear on seeing law enforcement, feeling of having been frozen in time, feeling of processing things at a slower speed. I was released with nothing. And although New York State has compensation statute on the books, you have to file a lawsuit, and it took me 5 years to get compensated. And so it was a very tenuous existence. I nearly ended up into a homeless shelter because I was always passed over for gainful employment. When I was released, everything I ever wanted to say but could never get it, when you hear me say, it all came out. And so I held the media there for 2.5 hours. So I gave a off-the-cuff presentation, and every time I thought I was finished, I remembered something else, and so I shared that. So at that moment, I realized I could be part of the innocence movement without necessarily being a lawyer. And so I embarked on this advocacy career, which involved in me doing presentations across the country. And I was a columnist for 5 years at the Westchester Guardian, and I made the decision to trade privacy for awareness. So I used to do frequent media interviews. I used to meet regularly with elected officials and go to legislative hearings and urge them to pass changes in the procedure in order to prevent future wrongful convictions. I received a scholarship from Mercy College, which I used to finish the bachelor's degree. And let me show show you a few more slides. After about 5 years, I was able to receive some financial compensation, and I decided I wanted to take my advocacy work to the next level. I started the Jeffrey Deskovic Foundation for Justice, whose purpose would be to free people who were in the same position that I was and to pursue policy changes. So this next slide, wait, something's happened here. I'm trying to get to the next slide. Give me 1 second here. Try this again. Okay, this is when I opened the foundation. So to my right in the red tie is Fernando Bermudez, who did 18 years in a Manhattan wrongful conviction case. To my left, that's Jabbar Collins, who did 16 years. And to his left, you might recognize Raymond Santana from the Central Park 5 case. If you get a chance to watch the series on Netflix, When They See Us, very powerful. I would definitely encourage that. The documentary about their story, Central Park 5, is probably the best documentary out there on wrongful conviction when it comes to the intersection of wrongful conviction and race. The first person that the foundation exonerated was William Lopez. He did 23.5 years for a shotgun murder in Brooklyn that he did not commit. He had pre-existing legal counsel that had been with him for 9 years. We entered the case and we did some investigative work, collaborating with those lawyers, and we were able to help turn up some additional evidence of innocence. And he was exonerated. We've been able to free 7 people in our 7 years of existence. Lopez passed away after living for 1.5 years as a free person, so his whole adult life was virtually stolen from him. I want to add that when he was originally convicted, his daughter was 1.5 years, and by the time he was free, she was 25 years old. Second person we exonerated, to my left with the red tie, that's William Hawley, who did 8 years and 4 months in an arson case that actually was an electrical fire. So we did that case completely in-house, and at the end of it, the district attorney agreed with us that he was innocent. We've been able to help pass 3 laws aimed at preventing wrongful conviction, working with other advocacy groups and organizations, including the Innocence Project, pertaining to videotaping interrogations and better identification procedures. We also advocated, the foundation advocated for the expansion of the DNA data bank, which is a step that New York took. I'm part of a coalition called It Could Happen to You, which is a statewide coalition, and we've worked together on wrongful conviction prevention and also against false accusations. We were able to pass 3 additional laws, including the Commission on Prosecutor Conduct. So it was an oversight board for prosecutors. We passed a tweak to that law, and we also helped on the passage of discovery reform, which pertains to sharing information between the prosecutors and the defense, so that a trial could really be a search for the truth rather than trial by ambush. I've spoken at internationally also. This being an example of it. Here I was in the country of Armenia, relatively new democracy there. The government doesn't believe that there is any such thing as wrongful conviction, and certainly not a false confession. So I was brought in as one of two American experts, and we engaged in a week-long series of events, speaking events, media, meeting with elected officials, etc. So this picture is an example of that. I got an award in exchange for my advocacy work in passing the Commission on Prosecutor Conduct. To my left with the long red tie is Bill Bassett, who started the group, who was falsely accused of a rape which he didn't commit. He was acquitted in 2 hours, but it cost him his reputation and his second mortgage, and it wiped out his savings. He had been a elected official up in Rochester, Monroe County, New York, and this is Professor Gershman, who does frequent media commentary on prosecutorial misconduct. So I got an award for my role there. I had to meet with a lot of elected officials and do media interviews and talk about my case. And most importantly, I was a liaison for the group with other exonerees. So for my role in that, I got an award. We're currently, having met with some success in New York, we're now working in Pennsylvania and California. This is an example of the Pennsylvania team. So that same model, putting together a coalition group and the same advocacy tactics. We'd have a team in PA and California. So Bill Bassett and I are the only people that are really in common with all the groups. So the tall fellow with the baseball cap is Drew Whitley, who did 20 years. This is Terrence Lewis, who did 21 years and 4 months. And to my immediate left is Mark Whitaker, who did 17 years and 4 months. Speaking of mothers, in the burgundy suit is Millie Saliga, whose son is fighting a wrongful conviction case now. And in the glasses is Marianne Lubis, whose son, Michael DeLoe, was excluded by DNA, but he was convicted anyway in a child molestation case, and they're currently seeking exoneration. And the lady in the front in the black, that's Karen Mills. So her husband is represented by the Innocence Project in New York, Craig Cooley, and another legal entity in Pennsylvania. The fight against wrongful conviction is not anti-law enforcement. It's not anti-cop. It's not anti-prosecutor. It is, however, against rogue police officers and rogue prosecutors and anyone who breaks the rules, breaks the law, goes against proper procedure. So I'm certified as an instructor in police academies in New Jersey, where for the last 5 or 6 years, they've been brought me in twice a year to speak to police cadets on the topic of ethics, and I squeeze in some best practices as well. So I co-teach that. So this is an example of that. Here's another class, and here's another one. It was a group of correction officers that I spoke in front of as well. After getting the scholarship from Mercy College to finish the bachelor's degree, I did the springboard from that to further education. So I do have a master's degree from the John Jay College of Criminal Justice. My master's thesis was on wrongful conviction causes and reform. So this is when I graduated. And this is a media interview when I did that. This past May, I graduated from the Elizabeth Haub School of Law at Pace University. I got a law degree. I recently passed the bar. My rationale for going into law school was that it wasn't enough for me to sit in the front row of the courtroom. I wanted to represent some of the clients myself. And I thought that the extra credential would not only allow that, but also would help the policy initiatives that I'm pursuing. One of the questions that I get often is, am I angry? And my answer is no, because I want to enjoy myself as much as I can and living a meaningful life. And I don't think I can do that if I'm angry or bitter. If I was angry or bitter, I feel like I would in effect be losing the rest of my life, and I would be the only loser in that. Perhaps less nobly, it's not like I would be adversely affecting anybody if I was angry or bitter. So that's my lines of reasoning on that, and the vehicle that allows me to actualize that is that I take that energy that I feel and I channel it into my advocacy work. The National Registry of Exonerations is considered to be the authoritative website and source on which catalogs wrongful convictions across the country, both DNA and non-DNA. There are over 2,500 listed exonerations there. In fact, I think it's over 2,600. And so unfortunately, what happened to me is not rare. I wish that it was. 19 people that I did time with were either exonerated before me or after me. Um, so maybe the last quick thing I'll mention is one of the major causes of wrongful convictions, prosecutorial misconduct. So we are working to bring the Commission on Prosecutor Conduct in Pennsylvania. As I mentioned, we are building that coalition out there, which is consisted of exonerees, people falsely accused but acquitted, individual advocates, everyday citizens, people who allege that their family and friends are wrongfully imprisoned, as well as all the different criminal justice organizations, regardless of what issue it is that they focus in on. We come together just to work on that. So we're working on three things in Pennsylvania now. We're working on the Commission on Prosecutor Conduct. We are working on automatic expungement. So we're saying there that when someone is exonerated in court, that their record should automatically be cleaned. That's not what the situation is now. And so a lot of Pennsylvania exonerees still have a record, and that hurts them when it comes to employment and other aspects. Pennsylvania is one of 15 states that does not have compensation. So that's another reform we're working on there. We're trying to pass the commission in California as well and fix their compensation system. Wrongful conviction causes, coerced false confessions in 25% of the cases, misidentification in 75, lying informants, bad lawyering. We need to limit the number of cases that a defense attorney takes at once. It's not unusual for them to represent 100 people at the same time. We need to have an even playing field when it comes to the financial resources and manpower between the public defender's office and the prosecutor's office. Certainly, we need everyone to be able to get compensation and immediate reentry services, things like cost of living, housing, mental health services, doctor and dental care, access to public transportation, job training, job placement, education. With that, I'm going to open up for questions. Feel free to ask me anything you like, whether it pertains to something that I've spoken about or even something that has not. In terms of just being timely, I do have a big concern when it comes to COVID-19. It's spreading like wildfire in the prisons, and so I think that it's very difficult to do social distancing there. So people that don't need to be incarcerated right now for public safety, I think that they should be released. So people that have compromised immune systems, the elderly, people who are incarcerated for nonviolent offenses, people that are within 1, maybe 2 years of going to see the parole board, who can be determined to have been rehabilitated and therefore able to safely be released. I think that that should be done. Certainly providing masks and sanitizer. I mean, there's been some reports that there's not enough of that going on, so I feel strongly about that. I do have a secondary interest in parole reform. I think people that have been rehabilitated should be released. I don't think people should be returned to prison on technical violations. I mean, I saw people return back to prison for a year or two, sometimes on things like, their curfew was 9 o'clock and they got back in at 9:05, or they didn't tell the parole officer that they changed an address. And while I think that there should be an adhering to the rules, I don't think that returning someone to prison for a year or two is the proper remedy, proper punishment for that. I did 28 days in solitary confinement. So, I mean, solitary confinement is recognized as a form of torture, and it causes mental health illness. It exasperates mental health illnesses. I saw a lot of people in prison that really didn't belong in prison. They belonged in a mental hospital. So that there's that issue. Prison reform, I think that there should be college education, vocational shops that have up-to-date curriculum and make sure that the instructors are actually teaching people instead of just being there for a paycheck. There should be more assistance in terms of prisoner reentry, ban the box. So, I mean, there's a disturbing practice amongst some colleges that applicants have to disclose whether they have a criminal record or not. And to me, if someone's applying to go to college, they obviously intend to engage in a crime-free life. And so why should they be denied an educational opportunity for that? Similarly, stopping people from getting this discrimination by employers. If returning citizens are denied gainful employment, then the temptation to return back to crime, to the old ways, and hence reincarceration, another victim, spending money to incarcerate them yearly rather than having them pay into the tax base. That's the end result of that. And so I don't, we got to have better measures when it comes to that. So all those issues, matter to me. And, just as the people that are there that are over sentenced, I saw people there who had more time in nonviolent cases that were there who, who killed people. I mean, that's backwards to me. I think when people have been finished their sentence minimum, they've been shown to be rehabilitated. They should be released. And I think, again, when it comes to elderly in prison or people with serious illnesses, they should be released because the prison is simply not equipped to deal with their advanced needs. And I don't think that sentences should turn into a de facto death sentence. I mean, these are, grandmothers, grandfathers, mothers, and, mothers, fathers, and, sons and daughters. And, humanity is not, dehumanization is simply not an option. And when we do that as a society, then we lower ourselves down to the level of the offender, or even worse. So look, I've spoken enough. I will open the door for questions. Feel free to ask me about anything you want, whether I've spoken about it here today or not. I'm very open. I'm very comfortable.
Okay, thank you, Jeffrey, for that extremely moving talk. I'm going to hand it over to Rob to manage the questions. I do want to say a couple things. First, we ask that you, if you have a question, that it be a question, not a statement. We're also going to limit questions to under 1 minute. And we'd also like to hear from some new voices in the questions, people who may not have asked questions at prior meetings. So with that, I'll hand it over to Rob. Go ahead, Rob.
Great. Thank you very much. It was such a wonderful speech, such a wonderful platform. Let's go to Beth and Perry. Go ahead, ask your question.
Am I unmuted?
You are unmuted.
Hi. Thank you, Jeff, for that talk. And I really admire you for being able to rebuild your life in a positive way instead of in a bitter negative way. My question has to do with what happened to the 2 police officers who interrogated you? Did you ever receive an apology? Were they punished in any way? Have you ever heard anything about them since?
So they have never been punished. I did sue the municipality that they worked for, but that's the entity that paid out. They didn't personally pay anything. They never. They were retired by the time I was exonerated, so they were never disciplined, or there was nothing on the pension. I feel strongly that they should have, there should be a criminal penalty for them for what they did, especially not just sending me to prison wrongfully and then an impact on my family, but then costing the second victim ultimately her life. In fact, the lieutenant that oversaw everything, he not only became the police chief based in part on my case, but they also stayed with him as the police chief. Even after I emerged, they allowed him to continue on the job for another 6 or 7 years. I never got an apology from any of the people that were involved, with the exception that the actual perpetrator, he apologized for remaining quiet while I was doing time for his crime. I did get an apology from the prosecutor and the judge in the courtroom, but those were not their counterparts who were originally involved into my case.
All right, we have a question from Lisa Schwartz. Lisa, go ahead. I think you have to unmute yourself there. Let's see. Try one more time. Ron, Lisa, there you go.
Yeah,
All
it's
right.
actually Ron. Ron has the question.
Oh, Ron.
Hi, Jeffrey.
Hi.
As an both a public defender and an ex-prosecutor myself, I was wondering if you could comment on what I have observed to be the tremendous imbalance between funding of prosecutors' office and public defenders' offices, and how much do you feel the wrongful conviction problem we have in this country is due to the tremendous underfunding and over caseloads that public defenders have.
Yes, I think it's a tremendous factor. Bad lawyering is a major factor, wrongful convictions. So I think that in terms of addressing it, I believe in having one statewide system so there can be greater oversight and quality control, evening out of the financial and manpower resources between the DA's office and the public defender's office, limitation on the caseload. Also, I believe in having equal pay for both sides. I think that both defense and prosecutors, they're playing a critical role. It's equal. One is not a more important job than the other. So I think that those things, all those factors need to be part of reform when it comes to public defense. And I'll just say that there's different civil liberties unions in certain states that have filed lawsuits against the state for not providing adequate funding.
Okay, sorry. Yes, let's go to Matt. Matt, go ahead. You're unmuted.
Hi, Jeff. So much for being and for sharing your powerful story with everyone. I wanted to ask about recording of interrogations, about the reforms to prevent false confessions. If you can talk a bit about what you see happening nationwide, which states are doing the best, what's the gold standard of that reform, and how's it going?
So the gold standard of the reform would be videotaping interrogations from beginning to end. The camera is supposed to be focused in on the both the law enforcement as well as the suspect. It makes for better evidence. It prevents police officers from leaving details out of their testimony, which is what happened in my case, and we can, get away from having to rely on officer memory and truthfulness. It does protect honest cops from false allegations of coercion. And I think it can speed things up. New Jersey's doing an excellent job when it comes to videotaping interrogations. I mean, the reform can be implemented either through a high court decision, or it could also be implemented through legislation. In terms of New York, where I'm from, so we passed the law there, but the problem is that it came out watered down. So they made exception for second-degree murder, sex offenses, and drug cases. So we want to try to get rid of those exceptions. But if you go to the Innocence Project's website, which we'll put up before the presentation's finished, it lists a breakdown of like how all the different states are doing. I'll say that there's a lot of pushback when it comes to the District Attorneys Association. Law enforcement doesn't want it, but ironically, in jurisdictions where the police are forced to do it, once they start doing it, they never want to go back. They see how it works in their behalf. Some of the pushback arguments are that suspects aren't going to be willing to speak if they're recorded, and my answer to that is they don't have to have a choice. Just roll the camera, and they don't have to see it. There's a cost site argument, which doesn't make any sense to me, because I think if you prevent just one wrongful conviction, then it's definitely worth it. The money that would be saved on the compensation side of it, and then what's the price on someone's life? So there's that argument. Then there's a silly argument, well, maybe the equipment might malfunction, or the public might not understand what we're doing in the interrogation room. But I reject those arguments. I mean, if it malfunctions, it malfunctions. If it's a real malfunction. But the idea that the public won't understand, I believe in transparency, and so that argument doesn't really fly with me. But in order to prevent wrongful convictions on false confessions, it's more than just the recording. Admission of false confession expert testimony in the courtroom is critical. They don't give an opinion on whether a confession is false or not. That's up to the jury to decide. But instead, it just provides contextual information to the general public about what are the factors that have been proven to cause innocent people to confess. Another measure that is gaining some steam is that there should be a pretrial hearing where the accuracy or truthfulness of a confession is also evaluated before it's allowed as evidence rather than just the voluntariness of it. So there are red flags, there are commonalities in many of the wrongful conviction cases caused by coerced false confession. And so, you can have like a checklist of all these factors that have been proven before, and that could be part of what the judge takes into account. Lastly, I just want to share that while adults have given coerced false confessions, particularly vulnerable populations are youth and people with mental health issues. I mean, to compensate for their mental deficiencies, people with mental health issues, they try to be compliant with authority figures. So when you match that with a police officer that's trying to get a confession, that's a bad combination.
All right, we have only time for a couple more questions, I think. We'll go to Lee Buchanan right now. Lee, go ahead.
Hi, Jeff, I was interested in the emphasis on psychological profiling and their initial identifying of you, and it seemed to sort of set them off on a kind of tunnel vision, a quest down that path. And I'm curious to what extent the psychological profiling continued to be something that they were relying on, building this case, and refusing to sort of look at other evidence.
Yeah, I mean, I think that it was a reinforcing factor on their end. Tunnel vision is a major cause of wrongful conviction. It's when someone forms a conclusion and then they only look for evidence to support that conclusion and ignore other evidence and come up with bizarre explanations rather than just going whichever way the evidence flowed. That having been said, I do want to share that I don't consider that what happened to me to be a good faith error, because the bottom drops out of that argument when you think about that. Not only did they know the interrogation tactics that they engaged in, including the false promise, but also the police went into the field and they interviewed 17 witnesses who knew the victim in one capacity or another, and they all told the police that she didn't have a boyfriend, there was no consensual sex, and the police purposely did not document any of those witness interviews, and so therefore that was not known by the defense. They didn't have to turn it over. I only learned about that aspect in the course of the lawsuit many years later. So there was that part to it also. But lastly, not to get too far in the weeds, but not content with having coerced a confession from me with the threat to false promise, but they also fabricated a statement and attributed it to me. The police claimed that this is the polygraphist and one of the other police officers. They claimed that I told them that I didn't know whether the perpetrator ejaculated or not, and they attributed that to me in order to help the prosecutor fight against the DNA test. But I never said that. I mean, firstly, that wasn't in my vocabulary as a 16-year-old. And secondly, as the judge in this federal lawsuit pointed out, that statement never appeared in any of their reports about what happened in the interrogation. That never appeared until after the DNA didn't match me. That's when they suddenly included it in their write-up. So for all those factors, I don't consider that it was a good faith error on the part of the police.
And our final question will come from Alan Berger. Alan, go ahead. You're unmuted.
Okay, Jeff, thank you so much for tremendous presentation and story. I don't know if you've heard of Liberation Prison Yoga, but we go into prisons to work with people around trauma through yoga and meditation. I was just wondering, even in prison or when you came out, what tools or how did you deal with the trauma of that experience from all those years?
Well, definitely seeing mental health professionals. I mean, to get specifically into it, I mean, there was client-centered therapy that was part of it, and I did spend some of the time just focusing on managing life, so activities of daily living. I did also utilize EMDR, so eye movement desensitization. So what happens is that it's a technique. It involves a light and it involves remembering traumatic experiences, and so the end result is that it seeks to remove the emotion away from traumatic experiences so that you don't have the reaction. So I think that those things were really big. Certainly, the more technology I learned, the more tied into the world that I felt. I did meet key people along the way who helped me with one thing or another, and I think that the people that were there for a certain period of time, those were much more helpful than just regular people, because it gave me something stable and consistent in an otherwise uncertain world. I haven't heard of the. Well, actually, yeah, I did hear the prison yoga. They were just getting started with that in New York, at least at the time when, I was shortly before I was exonerated. But I want to, hats off to you on doing that. Continue to do that. I know that in general, prisoners we really value contact with the outside. We really appreciate the volunteers coming in. That's the highlight of the month. It could be the highlight of the year. So that's really good. I'll share that. I do co-own a game called Recharge Beyond the Bars Reentry game, which facilitates reentry for formerly incarcerated people. It helps them to connect with friends and family through posing icebreaker type questions. And we also have a prison version of that. So I will just wanted to mention that as well. We need more of the program you're mentioning and other programs and techniques, and we need to cut down on just the verbal abuse and that goes on between when the guards are not professional and no one corrects them, and the violence prisoners against prisoners. I mean, we really need to stop having rehabilitation in prison happen despite the prison, and instead more because of it. When we look at other countries in Europe, they seem to be light years ahead of us in terms of how they treat prisoners and how their whole prison system is. So, I feel strongly about that, because people are sent to prison as punishment, right? They're not sent to prison for punishment. There's a, really big difference in that. I want to just quickly take a second. I'll be fast, but I just want to share one story, really quickly. Just speaking to the idea of dehumanization not being an option. I remember that I was in the federal court during my lawsuit, and we brought the actual perpetrator in a deposition. The theory of it was that we were trying to show that the police theory of how the crime happened, that matched my coerced confession, that idea came from them, but that wasn't how the actual crime happened. And so to establish how the crime happened, we called the actual perpetrator. And while we were there in that deposition, somebody told me when we got close to lunch that hey, he's not going to eat, and they laughed about it. And I said, well, what do you mean? Well, no, we're going to burn him. He's not going to eat. He's not going to eat anything. And I said, no, you're not. He's going to eat. And I was told, well, what do you care? Look, he killed 2 people. He remained silent while you were doing time for his crime. And then they said something else derogatory about him. Okay, I'm not going to repeat. I think you can figure out. So I said, no, you know what? That's why he's locked up. That's why he's incarcerated. Okay, he's going to eat. You're going to ask him, as a matter of fact, you're going to ask him, when we come back in here, you're going to ask him, did he eat lunch? And if you don't, I am. And so we came back after lunch. He was asked in my presence, was he given something to eat, and it was confirmed, that he did. And so, I mean, in that moment, I felt really not just really good about myself, but I mean, that's an illustration. I mean, dehumanization is not an option. I mean, looking at terrible things that people do, or even things that terrible people do, that can't be a reason for mistreatment. There's a level below which we shouldn't go. And if we do that, then we betray ourselves and our own humanity.
Thank you, Jeff. That is an extraordinary story, deeply moving. We really appreciate your coming out. Well, you didn't come out, obviously.
Yeah,
right. You know what I mean, right? Thank you very much. I'd like to